All right, I want to turn our attention to the question of major junior hockey, which I guess is going to maybe have a different name. I know we're changing the names of some of the other levels of hockey, but major junior hockey. It's not quite minor hockey, obviously, but it's not quite professional hockey. Or maybe it is professional hockey. Certainly, these are businesses. The companies, the individuals that own major junior CHL hockey teams are certainly in it to make a dollar. And some of these junior hockey teams do make a lot of money. So are these players employees? Well, there's been a lot of debate around that for a long time. Now, that brings us to what's happening here in Alberta. And a decision by the Alberta government to amend the Employment Standards Act to specifically carve out an exemption for the Western Hockey League. So that makes Alberta-based WHL clubs eligible to pay their players below minimum wage, essentially. So should they be paid at all? Should they be considered employees? Should they have rights under employment legislation? Well, there were a lot of those who were advocating for exactly that, and a lot of concern being raised about what this decision might mean. So joining us for some further thoughts on all of this, very pleased to welcome to the program here this afternoon, Randy Gumley. Is a spokesperson with the World Association of Ice Hockey Players Union, the North American division, representing players in Canada. Randy, thanks for making some time for us here. Welcome to the program.
Thanks very much.
All right, so what's the concern about what the Alberta government has done here?
Well, I think the main concern is that they actually just carved out a whole section or a whole business without any consultation with any of the groups or the players or the employees that are involved. That's somewhat worrisome. But I think the bigger picture is that these young men who work for these for-profit businesses, and these are for-profit businesses who generate an estimated about $400 million a year in revenue, but yet fail to comply with employment standards laws for the last 2 decades after being notified that these players were in previous court filings, actual players that are considered employees under the Government Act. Mm-hmm. And the league is a professional league. It's self-admitted that the league is a professional league in their own filings and corporate documents, contractual obligations with CHL and USA Hockey, and more importantly, business filing applications such as trademark, where they put down that their league is a professional league, not to mention their very own lease agreements with municipalities that call them professional. The only reason now they want to be called amateur within the government system is to try and mitigate their damages in the class action proceeding that was filed against them in 2014. And the bigger issue with that is that these teams and the leadership in the Hockey Canada and the CHL, they want to keep it as an amateur league for government purposes, but a professional league outside the auspices of hockey, because that contaminates a player, disqualifies a player from being eligible to the NCAA. So they want to have the best of both worlds. They want to have these kids as amateur athletes, even though there's about $100 million in NHL salaries contributed to these players right now that are playing in the CHL and under contract by National Hockey League teams and paid by National Hockey League teams in signing bonuses up to $90,000 a player. But they want that to be considered an amateur athlete. And thank God the federal government has stepped in to say that they're not. Recently, just in Alberta, there was an application for some funding with the infrastructure where the federal government refused to grant the money because the Red Deer team is considered a pro team. Now, the CHL has known about this this is not something that's been secret for them. They've known about it since 2000, since that court case came to fruition with the Merrick-Kerman case that classified players as employees, but yet they tried to conduct business and try and circumvent labor laws in order to not pay these kids, which is really a disgrace. And I think that the government in Alberta has done an injustice here, given the climate of hockey right now, with all of the abuses that are coming out against players, if you can't get an NHL player to speak out about abuse 10 years after he's left the game, how can you expect a 16-year-old or a 20-year-old to speak out why he's trying to earn a trade in that area? And all that the Kenney government has done here is taken away one avenue or one level of protection that would allow these kids a different avenue to report either abuses or to have other types of protections under the Employment Standards Act.
Right. I mean, it's interesting when it comes to junior hockey in Canada because employment standards, labor laws, it's provincial. So in the WHL's case, there's a couple teams in Manitoba, teams in Saskatchewan, some teams in Alberta, some teams in BC, and even some teams in the United States. So right. How does that work in practice then when you've got a league that covers all these different jurisdictions, but then you've got provinces with their own laws? Because obviously the Alberta rules only apply to the Alberta teams, right?
Right, and again, some of the other provinces have amended the employment standards laws to reflect that. But I want to take a step back. These government officials that change or amend these laws are being lobbied by these very powerful hockey. It's bigger than the church. I mean, let's be honest. Hockey is, Canada's game. Everyone thinks it's same. But Hockey Canada and the CHL has operated for decades under a cloud of secrecy. No one knows where the funds are going. No one knows where these investigations into these allegations of, abuse takes place. It's all done for clout. But these government officials that get lobbied are fed a picture. And that was very relevant in the BC lobbying efforts. We got an FOI request from the BC government on how they were lobbied. And ironically, which was left out in the information to the government, was about $100 million worth of revenue. So how can these government officials, without properly investigating and looking at the whole scope of this business model, because it's not limited to the CHL. Nobody in Canada or U.S. even thinks about who's the major benefactor of this. You may think it's the CHL clubs and the owners. It's not. The National Hockey League is the major benefactor of all of these employment law changes because they get to restrict the trade of players that are drafted within the National Hockey League, assign them to CHL teams from the age of 18 to 20, pay them a minimum wage or not a minimum wage, but a wage of $50 a week if they're not signing bonuses, but yet they still own their rights. And ironically, in the WHL, a player who signs, I hope you're sitting down for this, who enters into a contract with a WHL team, if he wants to leave that team to go and pursue another avenue of career in an actual trade hockey organization that would pay him a salary, the player must pay the team a $500,000 release fee.
Really?
Yeah. So, and that's in the standard player contract. So when you think about why that is in place, it's because the CHL's business model is to gear and put all the talent to the National Hockey League.
So if an 18-year-old playing in the WHL gets an offer from a team in Europe, a pro team in Europe, that he would have to, that's how he would get out of the WHL contract.
That's right. He would have to pay $500,000, or the team would have to pay $500,000. So it's meant as a deterrent. Considering that National Hockey League teams only pay up to $200,000 for developmental fee for a thing, you're asking another league to pay almost 3 times much more than what a $6 billion industry pays for player development within the CHL system.
All right. So, regarding the change in Alberta, so under the Employment Standards Act, it defines the term employee. An employee does not refer to an amateur athlete. Then it goes on to say an amateur athlete would include an individual who is a player on a Western Hockey League team. So it's very specific change in wording here. How should the Alberta government have handled this then, in your view?
Well, I mean, is it really up to the Alberta government to determine what an amateur athlete and what a professional athlete is? I mean, let's be clear here. If the CHL and WHL teams can't, by their own bylaws and own agreements, which they classify players as professional, if they classify them as professional, why are they going to the government to ask them for amateur status when the Amateur Athletic Association doesn't have them? And then they try and hide behind the umbrella that, well, we're members of Hockey Canada. Well, the Canadian Hockey League is not a member of Hockey Canada. The Canadian Hockey League is a partner, so is the National Hockey League. It doesn't mean that the National Hockey League is an amateur league. And this is a problem because all of these government officials are being fed the same Kool-Aid, and they're all drinking it because they think it's hockey, and they think that these guys are really actually after the best interest of the players, when it's really, this is about money and about not having to pay players. And the teams are not scared of minimum wage. A couple $100,000 a year would be nothing for these guys. What they are scared of is the agents will come in, and for top talent, they won't be asking for minimum wage. And the NHL will have to ante up some more money. But how should the government have conducted this? I think what they should have done is ask for the books. Let's see the business model. Let's talk to the players. And you can always tell at a government when they're really proud of the work that they've done in creating changes or creating some sort of business model or government legislation that they're proud to declare. They hold out the red carpet and they do a really good promo about this. This was done in secrecy. This was done as an order in council. This was done just by a press release and hoping right around Christmas time in the midst of a hockey climate where there's other issues that are in the forefront in the hopes that this would just fall by the wayside. Well, unfortunately, it's not, because these players want to get paid. And that's quite evident in Alberta in the class action lawsuit where there was over 1,000 players that were contacted to see if they would opt out of the class action. Only 61 players opted out, and the majority of those players are current players in the National Hockey League or are working with clubs within the CHL or NHL. And they just want to have the fear of reprisal against them. It's not so much the protection of the elite athlete. We're looking at the kids that are trying to earn a scholarship within the CHL, but are contaminated deliberately from obtaining scholarships to the NCAA because the CHL classifies their own players as professional.
Yeah, it is a strange situation. I agree. Randy, we got to leave it there. Much more, WAIPU.ca. Thanks so much for coming on with us here this afternoon. Appreciate it.
Thanks very much.
All right. Randy Gumbley, spokesperson with the World Association of Ice Hockey Player Unions, WAIPU.ca. And look, he's got a point that the CHL does seem to want to have it both ways when it comes to whether or not these are professional athletes. And clearly the NCAA recognizes them as professional athletes, which is why you can't get a scholarship if you're playing in the CHL. Now, you do get the opportunity to play top-level hockey. You've got the opportunity to get a university scholarship if you play 4 years in the CHL. But how do we recognize these players? And how should labor laws, employment standards laws recognize these players? And there's some big questions there.